Welcome everybody to Legal Tech Week for September 10th, 2021. I'm looking to see whether anybody's joining, as it looks like our registrations might have gotten screwed up again. I see a few people joining here. That's a good sign. This is Bob Ambrogi. I am the host of the show. I also have a blog called Law Sites and a podcast called Law Next. And let's have our panelists introduce each other. Nikki, you want to kick us off?
Sure.
I say introduce each other. Introduce themselves. You don't have to introduce each other. Just introduce themselves.
I'm gonna magically change my virtual background while we're talking. I decided I didn't like it. So my name is Nikki Black. I have the ability to magically transport myself from place to place. Other than that, I am the legal technology evangelist at MyCase, and I write legal tech columns for Above the Law, ABA Journal, Daily Record, and weekly columns for Above the Law, or the MyCase blog. I'm a little confused today. Transporting kind of plays with your mind, so I wouldn't recommend doing that very often for those of you that also have that skill.
Where are you actually today?
I'm home.
Okay.
We were at
Not
a
in
lake
your yard,
over
not at your cottage.
well, we were at the cottage all summer while my husband was recovering from his surgery for cancer.
Yeah.
And now that school started, we're back home, and I am once again back home.
All right, good. And Victor, want to introduce yourself?
Hi, everyone. My name is Victor Lee. I am assistant managing editor for the ABA Journal. I do not have the power to teleport, and if I did, I probably would not care about legal tech so much. I'd probably be doing lots of other things with my powers. But so I thank Nikki for spending the time with us, and using her powers wisely. Hopefully, she doesn't to teleport into anyone get us in trouble. So
sounds good. Victoria, how about you?
Hi, everyone. My name is Victoria. I am a reporter at ALM, where I write mostly about legal tech news. And sadly, I wasn't a part of last week's discussion about Beyonce, but I'll see if I can transport myself to another area. Let's see.
There you go.
I'm in London at the Victoria Tube stop in central London.
No, I'm not so special. I was special before.
That's good, because for a minute when I saw the tiles, I thought you were in somebody's bathroom there. So that's good. Zach, how about you?
Hey, everybody. I'm Zach Warren. I'm the editor-in-chief of Legal Tech News. You'll also see me on law.com and other places. I also actually have an irrational fear. Ever since I watched that show Heroes on NBC as a kid, and they all got random powers, I've never really wanted to have powers like to travel or anything like that, because I feel like the government would kidnap me immediately and try and put it for their own uses. And I'm not good enough to actually keep that quiet.
As a kid, I'm just putting that out there. That was great. Thanks for that.
And last but not least, Joe.
Wait, is it last? Did Steve go? I didn't even.
Oh no, Steve didn't go.
Okay. Yeah. Okay. I was like, I can go now, but I was like, I think I still had 2 to go here. But yeah, I'm Joe Patrice.
You're
I'm
right.
from the editor of Above the Law. Well, I'm getting good at this because I had to host last week. So I'm now getting those skills.
Yeah. Like knowing
and I have
who's here.
Yeah. I have the magical ability to actually find a PlayStation 5, apparently, which I managed to get at 6 a.m. today because I was randomly awake when my local store told me that they had 5 units in stock. So I did the thing that no one else in the world is able to do.
Awesome. Now, last but not least, Steve. I guess I'm a little discombobulated today. I just came running into the office a minute before we started this thing, so I'm also just getting my bearings. But that's no excuse.
That's all right. Maybe I may be last and least for all I know. But, I'm Steve Embry. I write the blog Tech Law Crossroads, and I am also chair-elect of the ABA Law Practice Division. I too missed the performance of last week, and I'm sorry for that, but I'm back this week. And I only have one question for Nikki, and that is that really you, Nikki, or is it just an avatar?
It's a holographic projection, so it's even better than an avatar.
So, and I am sorry to report today the loss of one of our panelists, not in the fatal sense, but in the career move sense. Molly McDonough, who has been with us from the start on this. I don't know that she's actually announced her new job yet, so I won't spoil her thunder, but she does have a new job, and that new job prohibits her from participating in this panel. So she is hanging up her cleats, and Caroline Hill, I don't know where she is this week. I don't think I ever heard from her on whether she was going to be here or not, but hopefully she'll be back next week. She may well have emailed me. I guess people keep emailing me to tell me I haven't read their emails, which seems to kind of defeat the purpose, but I'm sure we all know how that goes. So a few things to get to this week. And I don't know, where should we start? Victoria, you want to kick us off today talking about robots, machines?
Yeah, the AI overlord is trying to take over our patent system.
Which Nikki welcomes.
Definitely. It's kind of like a follow-up. I didn't write the follow-up, but just kind of like a follow-up that I wrote about just in the development of, I believe it's called DABUS, DABUS, a patent where they're saying that the inventor of the patent is AI. Now the owner would be people, but they're just saying that the person that created the patent was AI. And my colleague Scott Graham in California earlier this week wrote about how a US federal judge said that the patent couldn't be granted because a patent can't be, a patent has to be a person. And they were citing like the Constitution when they talk about himself, herself, believes, and how that can't be a computer. And now the judge didn't say that that could never happen, but that's something that the Congress would have to amend the laws to allow like a non-human to be a patent owner. And it's kind of like a follow-up from a couple months ago in South Africa and Australia. This DABUS, they received patent or the ability, I think they received like a patent for their invention, and they listed AI as the inventor. And just kind of like some people were saying like it's a good chances that they're not going to, no other US patent offices would grant that because it goes against kind of like what most laws say, and even some, I think, treaty agreements as well. So it's kind of interesting to see. From when I spoke a couple months ago to attorneys, they said DABUS likely wouldn't receive this patent because their type of AI isn't, I guess, like that's complicated that you would have a human programmer putting in or developing the algorithm to create that patent. So it's still a human person involved. But, you know, it's kind of everyone saying that at some point we might get to that point, and how do we deal with that?
Yeah, I thought that was really, I thought it's an interesting story. And I think it's, you just wonder how that's going to evolve. I mean, there is, I think there was just a story this week I saw about, AI getting the point of being able to write further AI, or at least be able to write different kinds of programs. And there's a book I read a few years ago, I think it's called The Ultimate Algorithm or something like that. I mean, all about this idea of being able to write this sort of core AI algorithm that could then have the capacity to write more sophisticated AI algorithms around different use cases and purposes. And if you get to that point of AI actually being able to create software applications or AI applications, shouldn't that be patentable somehow? I don't know.
Yeah, patentable by the people though. Like, I'm just trying to think in my mind, if they did grant it to an AI program or something like that, like what would happen then? Is it the AI program who is responsible for licensing it out or trying to enforce their own patent against people trying to infringe against it, like reapplying for different patents based off of it? Like, I feel like you could get into a wormhole very quickly by having something like that has nothing to do with the fact that the technology is entirely capable of creating something itself, but just more the practical issues that occur with it after that.
Yeah.
And then on the flip side, it's like if we accept that entities can be people and have free speech rights and have other types of rights, then it's like, well, then shouldn't they be allowed to patent things too, and shouldn't they have IP rights too? So it gets very confusing, and you kind of wonder where it's heading.
Yeah.
Yeah, and definitely was just kind of like they still keep like the owners or corporate entities can own the patent, they're the patent owners, but the inventor would be listed as AI. I remember speaking to a patent college professor, law professor, maybe like last year, and he said kind of like when you get into this and just like AI and computers creating patents, it's different from a human because a human has to take breaks. A human has to be inspired. They have to work. A computer, they can maybe crank out patents if you allow it. It's just kind of like it gets to that point where people still want to patent if you can so easily create patents, and kind of gets into like a wormhole. But you know, eventually, I guess like Congress people will have to make a decision about it.
In entirely related news, there's a new Matrix trailer. Yeah, no, it becomes kind of a wormhole. I was actually thinking that point, so I'm glad you mentioned that, Victoria. I was like, if the thing can be created that easily, like at what point is it actually all that unique? And that's one of those things that you need to be patentable. But yeah,
Go ahead. I'm sorry. Go ahead.
No. You go first. Wasn't paying attention to the.
Oh, okay. Well, I was just going to say it reminds me of that. Those rulings about what is or is not the unauthorized practice of law when an AI program does something that a lawyer used to do, and I seem to recall that there's a ruling someplace that says, well, no, if a machine can do it, then it can't be a practice of law, so it can't be the unauthorized practice of law. So only a human can do certain things. So maybe it's not entirely related, but it's as close as Joe's relationship with.
Well, then I think the problem about anything related to AI, to sort of touch on the tail end of what Victoria said, we'll just wait for the Congress to get around to it. We're going to be waiting a long time because we're still waiting for them to like amend that, you know, the 1983 Secure Communications Act. I'm not sure if I'm getting the name of that act right, but it takes them forever. You know, and the people in Congress definitely don't understand technology. I'm generalizing, a few of them do, but most of them don't. And so that's always been the challenge with technology and AI in particular. I would suggest biometrics and facial recognition and AI. And it's the concern that everybody talks about when they think AI is going to gain sentience, that the regulations can't keep up because Moore's law was broken a long time ago and everything's moving so fast. And legislation in Congress moves so slow.
Well,
so they decided that you can't regulate it.
If though you create an AI that can create regulations, what happens then? See, then it can keep up.
So are we going to have?
Why I hedge my bets.
Are we going to have a Republican AI and a Democrat AI?
I just feel like
this is why I welcome robots. Like
it's like
Rob alluded to at the beginning. Every single day on Twitter, every weekday, I welcome a new robot because they're going to take over, and you got to be on the good side.
It's like the flash crash that we had.
Nikki.
It's like that flash crash we had, except it would be regulations, where like every new thing is met by an immediate regulation until everything collapses.
I'll vote IBM in the primary in 2028. I don't.
Yeah.
I'm banking on. Does anyone watch Star Trek out there? You know, the Borg Queen was like actually human. That was like the bee in the middle of all the machines. That's who I'm going to be. You guys don't realize it, but I'm going to hold all the power of the world in my hand one day because I've been regularly welcoming them. They know I'm there, you know, on their side. So you just wait.
Well, I hope
so. Now, actually, I guess that raises another question: Is Nikki real? Or is it an avatar of artificial intelligence? Or
people have been saying to me forever, "Are you for real?" It's kind of a different tone than what you're saying, but you know.
Nikki's also the believer that we're all part of a computer simulation. So it's either robots taking over the world or we are part of a computer simulation. I kind of prefer the latter. I think. I don't know. All right. Well, let's. Why don't we keep with that? Was something that was in the news, and Steve, you got something right out of the news like today. So maybe we can talk about that.
That's a big story today. The Northern District California judge ruled on the Apple Epic antitrust unfair competition lawsuit that got a lot of notoriety a while back. Epic, of course, is the is the maker of Fortnite and the game Fortnite. And so what happens when you go to the App Store, the Apple App Store, and you buy an app, Apple gets 30% of it, 30% of the payment, if you will. And they don't give, or they historically haven't given any option to go someplace else, or for the developer to say, if you go to my website, you can save the 30%. And so Epic came along and said, well, that's a violation of the Sherman Antitrust Act because Apple is a monopoly. And it's also a violation of the California state statute. It's called the Unfair Competition Law, UCL, and it basically precludes unfair competition, which it defines as an unlawful practice, an unfair practice, a misleading practice, a deceptive practice. I've litigated several cases in California under the UCL, and it's really a kind of a mushy statute, if you will, because basically what you do is you find cases all over the place, and they don't necessarily make sense with one another. Like, what's unfair? What does that mean? So the big news is on the bigger claim, the Sherman Act, Antitrust Act. Apple won. The judge said they're not a monopoly. There are other options out there. Competition's not bad, but they lost on the UCL claim, because what Apple did is they basically didn't tell the consumer that there are other options for payment, that you can go outside the App Store and pay and save the 30% commission. And just as an aside, if you ever have gone to the Amazon app in the App Store and tried to get a ebook, a Kindle book, you can't do it. And the reason for that is Amazon Jeff Bezos really didn't like giving Steve Jobs 30%. So I'm not going to do it. So you have to go to the actual Amazon website. So how big of a deal is this? I don't know. Apple had already agreed in another class action suit to let developers use information that they get when you sign up for an app to contact customers and tell them here's another option. I really wonder, I don't know. I mean, you buy an app that's worth, that costs $1.99, which a lot of them do. Are you going to want to make 2 or 3 clicks to save, 60 cents so it's $2.59 on the App Store versus $1.99 if you click 3 times I don't know. I'm not real sure, but as I was telling Bob before we started, I mean, 30% of $1.99 is one thing. 30% of umpteen gazillion dollars, which is what Apple makes off the App Store, is entirely another thing. So obviously, it's going to be appealed, and there's going to be a lot of talk and consternation and arguments about it. But at least, to me, the big headline from it is Apple won on the antitrust claim, which I think is a pretty big deal.
Yeah.
Well, it's a super interesting decision too. If you want some light weekend reading, I definitely would say go and take a look at the decision in this case. I think it was a video games journalist, Jason Schreier, that I really like, used to be for Kotaku, who basically said, yeah, this decision is for everybody who hates both companies because both kind of lost here. Epic pretty much did lose on every single thing that they were trying to assert against Apple, particularly, as you were saying, Steve, that antitrust claim. But the one where Apple lost, that 30%, I think I've seen figures that just by virtue of Apple's App Store being so huge and so many people having iPhones, it could be in the billions that they lose. Yeah. Because of that. And that is a very big loss. So, I mean, Epic is going to have to pay damages for bringing this case, and that's in the millions. But I think ultimately, just in terms of raw numbers, it could be a worse loss for Apple.
Yeah, and it's interesting because the UCL is not a damage related statute. It's an injunctive related kind of statute. Now you can get restitution, under it, which is again a kind of a bizarre sort of concept. But the real power of it is it allows the court to enjoin Apple from continuing with the practice. And the winner gets their attorney's fees paid. So another interesting question is going to be how much of the Epic attorney's fees were spent on the UCL claim and how much on the, I mean, it's kind of a litigators, I won't use the word nightmare. That's the wrong word. A bonanza might be
Gold mine?
another word.
I never knew why I was not able to buy Kindle books out of my app. I learned something new today.
That's it. And Netflix is the same way. You can't get Netflix. You can't pay Netflix through the App Store. You have to go offline and do it.
Yeah.
So as a random aside, the college debate topic for the year is strengthening antitrust laws. So it's super exciting how quickly moving and changing all of this is. It really makes it easy to keep on top of the research when the entire field of law is changing every day. Super great. Super excited about it.
That's why they need coaches like you.
Yeah. Well,
Yeah.
We'll see.
For those who don't know, Joe is a debate coach in his spare time. I don't know when you have spare time, but
There's not a lot of it. Yeah.
So something we've talked a lot about on this program are the innovation effort, the re-regulation efforts in Utah and Arizona. As everybody knows, Arizona pretty much got rid of the ban on non-lawyer ownership of law practices last year, and Utah has its sandbox doing something similar. And Victor, the ABA came out with a ethics opinion this week that talks about an aspect of that.
Yeah. So like you said, the ABA released a formal opinion, I guess a couple of days ago, talking about what the outlining the steps for whether a lawyer can passively invest in an alternative business structure based in one of these states. And the answer was yes. Lawyers can do it. Obviously, there are all kinds of restrictions and things that they have to keep an eye on. I actually thought the opinion. I don't read too many of these ethical opinions. Maybe Nikki can weigh in on this, but I thought the opinion was pretty well reasoned and made a lot of sense. I mean, one thing that they said was that lawyers have to be cognizant of potential conflicts. So if they invest in one of these ABS these structures or whatnot, then that could affect whether or not they can then represent someone whose interests could potentially conflict with that. And one of the analogies they made was that lawyers are free to invest in all kinds of things in their spare time. They can invest in they can have ownership stakes in restaurants, they can invest in stocks, they can do all this and that. And if they have a client that comes in who has an interest adverse to one of those positions, then they have to either decline the representation, or they have to divest themselves of the potential conflict, or wall themselves off from their firm. So I actually thought that made a lot of sense, and it made a lot of it was written in a way that I think a lot of lawyers could probably relate to and understand. So I actually thought that was done well. And then one of the other things that they talked about was just I think the choice of law. If there is a dispute, obviously the choice of law would be a state where these things are allowed, because otherwise that'd be a little unfair for someone who invests in one of these things, then have to be governed by a state law where they aren't allowed to invest in these things. So I thought that made a lot of sense too. So kudos to whoever wrote it. But yeah, I thought it was an interesting opinion that obviously going forward we'll see just how widespread these structures are, and just whether or not lawyers do decide to invest in them, or whether they decide to just kind of edge on the side of caution for the time being. But I thought it was a well-written opinion, and it shed a lot of light on a tough subject that is probably of a lot of interest to lawyers.
Yeah. And Nikki, what did you think? Did you get a chance to read it? I know you write a lot about ethics.
That opinion I just skimmed on your blog, Bob, and read the headline. So unfortunately, I have not read that one in full.
All right.
And I haven't written about it.
Yeah, I agree with Victor. I thought it was a well-reasoned opinion, and I mean I saw a little bit of criticism of it on Twitter, and I mean I'm usually not shy about criticizing ABA ethics opinions on technology-related issues when I think they deserve it, but I thought this one was, I thought it basically was right. And I mean, basically it said, as you said, Victor, you can do it. If I'm a lawyer here in Massachusetts where 5.4 still exists, but I want to invest in one of those alternative business structures, I can do that. And really the only real caveat is to just be wary of conflicts of interest with clients you may have, or with clients you may take on going forward. If somehow the entity that you're investing in Arizona or whatever, somehow has dealings with somebody who might be your client as well, or somehow could implicate your client, then obviously you have to consider the conflict of interest issues. But yeah, that was
I
good.
mean, it strikes me as kind of humorous that we're all complimenting the ABA for such a nice opinion when, like, shouldn't it like be obvious? I mean, you can invest in another business as long as it's not a conflict.
Well, I think the problem is that if you're, I think what makes it a little muddier is just the idea that if you're in a state where 5.4 still exists, and you're investing under the fact that 5.4 has been eliminated in Arizona, it really kind of comes down in a sense to that choice of law issue that Victor was talking about. I mean, whose rules of professional conduct apply to you and how do they apply to you? So I think it gets a little muddy. I mean, it's not, yeah, maybe you're right. Maybe it should just be obvious, but I think it's not entirely clear. And
so if I invest in a cannabis company in California where it's legal, but I'm in Kentucky where it's illegal, then should I be concerned that? Oh, never mind. It gets. You're right. It's
not a law firm. It's not a law firm.
Yeah, it's a fact that it's a legal services entity that does make it a little muddier as well, as opposed to investing in a restaurant or something, but or a cannabis company. If you invest in a cannabis company, come to Massachusetts. It's legal here, and we've got plenty.
Yeah, although a cannabis dispensing law firm might not be a bad idea. I mean,
a mobile cannabis dispensing law firm, one of those like a little van that parks on a street corner and deals marijuana and legal advice. All right. Well, Nikki, since you hadn't read, so I caught you off guard on that one. What do you want to talk about this week?
Also, in keeping with the theme earlier of technology moving so quickly and people having a hard time keeping up, what I wanted to talk about was an article that was on Mashable, and it was about the the SpaceX, Blue Origin's lawsuit against SpaceX. And let me put this here into the chat so that people can see the article. But essentially what happened was that PDF issues caused a delay in the lawsuit, which I thought was really funny. Basically, it was really funny for any number of reasons. I mean, first, the problem was that the court's site wouldn't allow the upload of such large files. And so in terms of, it wasn't the website, it was the Department of Justice. And they wouldn't, the Court of Federal Claims online system only allowed for files of up to 50 megabytes in size. So to be uploaded. And what was so interesting to me was, I mean, anyone who's worked on just a basic civil litigation case knows how large files can be, let alone a case like that, that is so document intensive. And the idea that the site can't handle large PDF files, and my favorite part of it is, so they're now going to send it to them via a case of DVDs. I mean, come on, like, how is this like happening in 2021? And the whole thing got held up because the files were too big and they're sending DVDs. I mean, how are they even going to open the DVDs? I mean, they're probably going to have to go buy old, technology somewhere to open these things up. So yeah. I just was, it's amazing to me that, tech's moving so quickly, including the sizes of files and the ability to upload large amounts of files into the cloud or to share them online. And the fact that the software that's being used in a lot of places or the systems that are in place just can't handle it. And so I just thought it was super interesting and ironic.
Yeah, the court may have to swap out its floppy disk drive for a DVD drive.
Right. And it's just amazing to me that, you know, that they're in the legal space, these just simple tech issues keep arising as problems over and over again, whether it's lawyers screwing things up on Zoom or not knowing how to use tech, or posting stupid things online, or all these different tech issues that are just related to litigation that come up. And they're just still not getting solved, even though we're all working remotely and we need them to be solved at this point.
I think she's trying to set up a segue to Zach's story, but
my one comment on this one though is I'm just wondering, particularly like you saw under the pandemic, it was the impetus for a lot of judges, a lot of court systems to say, okay, we have to learn Zoom. Like we have no other choice here. I wonder if we are going to see something similar for documents and document submittal, whether there's going to be some sort of exciting factor or a major case that hinges on something like this. I mean, that's literally what's happening here, but to the point where there's enough of a public outcry that court systems say, oh, okay, this is worthwhile for us to actually budget out now. I don't know what that would be. I'm trying to rack my brain, but it's kind of an interesting thought exercise.
well, maybe just a deadline filing that you can't upload because it's a minute before the deadline and the system won't take it. That's I don't know if the court's going to be bothered by that so much as certainly the attorney is going to be bothered by it. The reverse of that we've seen cases where law firms have gotten, I was going to say they've gotten screwed, maybe they screwed up by getting notices from courts around electronic filings that were mislabeled and therefore caused the law firm to think it was a particular kind of a document coming to them, or more importantly, not think it was a particular document coming to them. There's the famous Sidley Austin case a couple of years ago where the notice from the court of a final order in a matter that started the clock running for filing an appeal, the notice from the court was mislabeled as to what the document was. And so Sidley Austin, whoever received it at the firm, just didn't bother to read the PDF, I guess, which happened to be a final order, final judgment of some kind, and set the clock running so they missed the time for filing an appeal. So I don't know if that really speaks to your point, Zach, but there's so many sort of areas of possible error in the whole federal courts docketing and filing system right now that it definitely needs to be upgraded substantially at some point. Pacer's only what now, 30 years old or something, 25, 30 years old. So.
They can't update it because updating Pacer in any way would cost billions and billions of dollars. They keep telling us.
Right.
And there are a few things that frustrate me more than the federal government pretending, the federal judiciary pretending that Pacer is this like cutting edge multi-billion-dollar project, as opposed to a bad access database that they cobbled together years ago.
Yeah, there's probably somebody in the audience today who could probably code a better Pacer right now than they've got.
Several people, I think, as I'm scanning over the attendees.
Yeah, right. Yeah. But that was sort of a segue to Zach's other story. Do you want to talk about your other story, Zach?
Sure.
Your other story, your story.
Yeah, as we're talking about ethics, I mean, it's not really so much of a story as much as a conversation that happened this week. So a judge out of a local court in Texas, Roy Ferguson, kind of went on Twitter and just kind of talked about, hey, you do realize that judges are reading everything you tweet, right? And we're kind of keeping that in the back of our mind when we're thinking about how attorneys should act in our courtroom and attorney ethics and what have you. And it just started a bit of a conversation where attorneys and judges were going back and forth a little bit about like not only what attorneys should be doing while on Twitter and how they should be conducting themselves, but also kind of on the opposite side, whether judges actually should be thinking about that or looking at that at all in the vein of being impartial as they're ruling on things. It's kind of an interesting conversation, particularly, judges and attorneys knowing about each other and conflicts of interest have been a thing forever, but social media just kind of adds a new element to it where a lot of people feel very empowered to speak their minds, sometimes on controversial subjects. So it's just something I feel a lot of people probably should keep in their back of their minds, maybe a little bit more than they do. And it probably will be a topic of conversation moving forward here, because I don't think it's going away anytime soon.
Yeah. There's a little bit of a, Steve, I don't know if you've ever had that. I mean, I don't know if you don't go to court much anymore, I guess, or I don't know if you practice at all anymore, but I don't go into court, but I am a lobbyist, and I go before the legislature, and I have had occasion where I'll go in. This literally happened where I was going to testify before a panel of legislators in our state, and one of them stopped to say, "Oh, I love your blog post about something or whatever." And I felt like it was my worlds colliding. It, like, I never really occurred to me that anybody in the state legislature would be reading my blog or even knew who I was, other than with my lawyer hat on, as opposed to my tech writer hat. And it was a little disconcerting to have that happen. I mean, it wasn't anything bad, and it was a totally innocuous exchange, but it kind of gave me the jitters a little bit.
You know, it's a good point, and I've given talks and presentations on it because you know, a lawyer takes a political position, particularly if you're a litigator. You take a political position in social media. There's so many people that can see it, including judges, potential jurors, adversaries, and it could impact your credibility, rightfully or wrongfully. I mean, whether you're on a good side or bad side of an issue, particularly these days when political issues are so polarized. I mean, you know, if I take a position on a political issue and people vehemently disagree with me and one of them pops up on a jury, that's probably not going to be good for my client. So, but, you know, people want to talk, they want to comment, they don't want to be shackled. And so it's kind of a bit of a fine line. My view is if you're going to be in court and practicing in front of juries and judges, you ought to be very cautious about what you say on social media about contentious kinds of issues. But that's just my philosophy.
I always tell lawyers when I write about the ethical issues as they come down, err on the side of caution and let it be somebody else's. It takes me back to when I took New York civil procedure in law school, and Professor Siegel, who's since died, but he was the one that wrote the commentary for the McKinney's, which is the statutes. And he was, really well known. He always taught this New York civil procedure class, and it was so interesting, even though the topic was so dry, because he was such a good professor. And a lot of the things he said have always stuck with me ever since. And one thing he always said was, let it be SEC, somebody else's case. Let somebody else, err on the side of caution. Let somebody else be the cutting edge, because if it's your case and you're the one and it doesn't go down, and you're doing something that's sort of questionable, or the law's not clear, and it gets litigated, and then you're on the losing side, your client's case has just been, just disappeared, and you have not done a good job. So always err on the side of caution. And I always tell lawyers to do that in social media. Let it be somebody else who the ethics committee looks at it and says, oh, you probably shouldn't have done that. Don't do it if you think it's questionable. Err on the side of caution. Don't say things that are going to come back and bite you in the butt. And the internet's forever. Just because you delete it, there's a thing called screenshots, and stuff can be, duplicated and shared and saved online, and it doesn't disappear. So just err on the side of caution and be careful, and don't let it be somebody else who loses their license, not you.
Well, you also get into issues, and I kind of got into this a little bit when I first started blogging and was still practicing, taking a position on a case, and thinking that you are aligned with most of your clients, and then discovering that your position doesn't align with some of your clients, which is bad enough. But the even worse part is to be in, and this did not happen to me, I will hasten to add, but to be in a court arguing a position on behalf of a client, and your adversary standing up and saying, that's really interesting, Mr. Embry. You actually wrote an article and published on LinkedIn with exactly the contrary position. So I mean, you think, okay, we're all big boys and girls here. The judge is going to say, yeah, well, okay, big deal. But I don't, That's a pretty uncomfortable position, especially if
Yeah.
your client's sitting in the courtroom with you.
Yeah. Yeah. But so Zach, your debate was kind of went to the question of whether judges should be looking at that stuff or thinking about that stuff themselves. I mean,
Yeah.
I don't know how you avoid it, but
Yeah, and I mean that's part of the thing is you like to think of judges as kind of on this ivory tower, kind of not really looking at anything but the case that's in front of them. But judges are human too, and I think sometimes it's a little bit tough to
until
avoid
the
that
AI
sort of-
overlords take over.
Yeah, until there are AI judges that make sure that we are doing the right thing. But yeah, that's Roy Ferguson in particular is a judge that I know that my colleagues at the Texas Lawyer have quoted a few times and is very outspoken. But I think it was also kind of interesting seeing a little bit of the blowback there. Like, well, why are you paying attention to this? Should you be paying attention to this? Kind of turning that on its ear. And it could be a point of contention, I think. Like, not in every case, certainly, but I could see it popping up.
Yeah.
I
Yeah, good.
Otherwise, I write a lot about judicial ethics opinions as well and what judges are supposed to do and not supposed to do. And I have a little bit of difficulty with this when people make, I'm not arguing with you in general, but when you have this online world and the offline world, and this idea that because the online world amplifies people's statements, amplifies people's behavior, makes it more accessible, that somehow judges shouldn't be looking at that, but then they're at a party with somebody. I always like to analogize things to the offline. So they're at a party with someone and a lawyer's over in the corner shooting their mouth off about some controversial subject, which I know very few lawyers do that because we like to keep our opinions to ourselves, but sometimes lawyers will do that. And I'm kidding, lawyers do not like to keep their opinions to themselves, but you know, I always feel like that is really analogous to this online behavior. You know, judges, their job, they can't be isolated and they can't live in bubbles. And sometimes we act like they're supposed to once they get elected or once they become appointed. Suddenly like exist in this ivory tower and never interact with anybody. So that way it won't influence their decision-making abilities. But we know they're people, they have families, they have friends, they go and they socialize with lawyers that appear in front of them sometimes. And their job is supposed to be to be able to be impartial and fair when they're making rulings. And even if they think this lawyer is a jerk, they're supposed to listen to his or her arguments and make their decision that way. And so I would suggest that probably it's inappropriate for them to be, if they know a lawyer is in front of them, to be constantly paying attention to what they're saying online. Although in some ways, maybe they should because they want to see if they're talking about the case. But I would suggest that their job's to be fair and impartial, and that's part of what they're supposed to do, and that they should be allowed to track and see what other lawyers are doing online and not live in an online bubble in that way. And so I think lawyers are people too, like just like you said, and I sort of go in a different direction with that. But
Well, yeah, you know, I guess, you know, I'm sitting here thinking about it as you were talking. It a lot of times when you appear in front of a judge, particularly if you're, you know, not real familiar with the judge, your credibility is really online. I mean, and, you know, when I was practicing locally, you know, I knew all the judges. I tried to be very forthright and honest with them with my arguments. And so when I said something, they would at least pay attention and think, if he says it's this way, there's a good argument that it is this way. Well, where you get into is, you know, you take some of the really contentious issues, and the one that popped in my head as you were talking, Nikki, is this whole controversy about vaccines, right? And so, you know, I'm a judge and I've had both vaccines. I strongly believe in them. But then a lawyer comes in that I know has been spouting off that vaccines are lunacy, that you're going to turn magnetic. And it's hard for me as a judge to say, how credible is he or she in front of me if they believe that, you know what, can I believe them? And so, you know, I hear what you're saying, and you're right, Nikki. I mean, if I were the judge, I should say, all right, I'm gonna give whatever argument he or she's making the same credibility as I'd give the other person. But then subconsciously, I don't know if I could do it, to tell you the truth.
Right. Yep. Let's move on to Joe Story, who goes from Beyonce last week to eDiscovery this week.
I mean, natural transition for my thinking. So I had an interesting story that the story itself actually isn't what I wanted to talk about, but something the story raised. When we were out at the Global Legal Tech Affairs penthouse atop the Mandalay Bay, reporting on things at ILTACon, at our AltaCon, as we called it. One of the interviews we had was with ActiveNav, and an interesting concept that they raised was, that a lot, while obviously an e-discovery player, they've shifted a lot of they pivoted to some extent to utilizing their platform for just general governance and data mapping, which is kind of a logical jump, right? Like when you think about e-discovery platforms, you think, oh yeah, those could be used for that kind of upstream of the data cycle. And it got me thinking whether or not that is kind of the future of where this area is going, because I think e-discovery, while it's not like it's not dynamic and things aren't still progressing, the idea of where the new market share is might be starting to dry up as everyone's kind of doing it. And is the future of this going to be the ability of vendors to see new use cases for the technology they've already developed, data governance, or perhaps something else? Is there some other place where they can use the technology they've already worked out? And is that kind of the future of what's happening there? And the folks that don't try to branch out in use cases, maybe that's the place where they're in trouble, or that's the place where they're going to get sucked up by somebody else who does have that kind of worldview.
Yeah, I think that's a really good point. I think in e-discovery that's been kind of slowly happening for a number of years. I mean, you've seen a lot of the products, especially some of maybe across the range, but I was going to say some of the more middle tier e-discovery products that aren't like the super big dominant ones, like maybe Relativity or something, where they've been one area that a lot of them expand into is marketing themselves to governments for handling public records requests. And that's been a big area for a number of them. And then another area is in doing compliance investigations, internal corporate enterprise compliance investigations, where the software can be really great for, going through reams of emails and other electronic documents, looking for evidence of some kind of unlawful bribery or that sort of thing in a compliance matter. So, but even beyond e-discovery, like you say, it's just the idea of taking a core technology and being able to expand it either into other use cases within legal or even into other verticals outside legal is really where, for some of these companies, the big future is, I think.
Yeah, and for me, it does kind of come back to the money too, which I think is part of what's really changing here, is particularly for a lot of the mid-sized companies, the ones that aren't necessarily Relativity, that are looking for increased funding to try and make a dent in this space. A lot of venture capital, they look at e-discovery and say, that's small potatoes. What we really want is an enterprise technology here.
Right.
Like, I'm actually thinking of a story that we just posted before this started. Hanzo, which is a e-discovery company, they focus on a lot of dynamic data like Slack. They got 10.5 million yesterday, I believe it is.
Yeah.
And yeah, we talked to them, and the CEO basically says, I'm going to read the quote here: "We see that the market now requires to be able to deal with more of these sources and also to be able to do more things once you have them. And more things can be related to discovery, but also to compliance, to data privacy." And that's one thing that the investor really liked about them. So I think as more money begins to flow in, I think it's going to be a necessity for these companies to really keep up with what their investors are demanding of them, to be able to spread out beyond just discovery into these other areas to keep the money rolling in as much as anything else.
Yeah.
I remember way back when I worked for like Law Technology News, I think I spoke to, I think it was Recomind. I don't know what they are now or who they're owned by. This is back when they were still independent, I guess. But like they were talking, this was right like right when Obamacare was starting up, and so they were like, their big thing was they were going to try to start coming through like medical records and trying to find, use their technology to market themselves as a way that you could just like rapidly go through records and search for things and whatnot. Obviously, there were, the privacy issues and whatnot that they had to be cognizant of and things like that. But I feel like anything where you have like a ton of volume and you need a way to go through it really quickly to search for things and to have like a method for finding data or deleting things would obviously be a natural move for some of these vendors. And yeah, I guess it remains to be seen like as to where they end up. But I mean, I would think that there were a lot of places where they could easily apply this technology. As a matter of whether or not they have the wherewithal to do it.
I did a story last year for a law tech for Above the Law on Maura Grossman developed the technology assisted review technology, using it to go through COVID literature, medical literature, to help find, to help sort of expedite research to find develop a vaccine for COVID. And I think Relativity also had a product along those lines too that talked about. So that's another example of that.
Yeah, and as a former litigator, I'm really sort of impressed with how they are taking the e-discovery, which is to me sort of a misnomer. I mean, that's like saying there's e-discovery and there's discovery.
Right.
It's all discovery these days, but they're taking these tools and they're allowing the lawyers to use them to develop their story, to develop the theory of the case, to put together all sorts of different tools to help them litigate the case, not just search for documents. So it's pretty interesting development. Several of them have come out with things that do just that.
Yeah. So, all right, well, I guess I can talk about my story. The only thing, the one story I wrote a number of stories this week, but the one I wanted to talk about was just Clio's acquisition. Clio this week announced that it acquired Lawya, a document automation and assembly platform. I just think it's interesting. I continue to be fascinated by the whole way in which the whole practice management world has evolved over the last decade, and starting really from Clio's early days, launched just over a decade ago. And supposedly I was the first one to write a blog post about Clio way back when, and followed them for years, followed MyCase for years, followed all these companies. Clio at this point, this is only its third acquisition, surprisingly, because it's feeling like such a big company, and it's got so much money. But I think this is the beginning of a lot more. I think I wouldn't be surprised if we heard of more even before their conference next month. Is that just next month? I think it is, right? Clio Cloud Conference. I just think it's as significant as the acquisition is, more significant is kind of the trend it represents of these companies getting bigger and bigger. MyCase has been making acquisitions. Other companies are all making acquisitions and coming together. And there's a whole trend of consolidation and growth going on with these platforms that for a long time were all kind of smallish companies.
Yeah, the fact that it was only its third ever is really what stood out to me in the story. That's interesting that you think more is coming, though, because
I don't have any inside information.
Well,
but I'm just yeah.
No, I mean, just looking at the numbers.
Hear that, SEC? He doesn't have any inside information.
No, just looking at the numbers, though, it was one for a long time, and then they made one in June or July, one now. So it seems like they are starting to tick up a little bit after years of only organic growth. They were kind of, to your point, kind of alone in that, because so many of these companies that previously were mid-market and have scaled up, have done it inorganically through M&A, that Clio was a little bit on an island like that. But yeah, now that they have the capital, it wouldn't surprise me to see that change.
Yeah. Well, I mean, yeah, I mean, in my case was not doing any acquisitions for the longest time or anything like that. I mean, my case was just developing everything in-house, and kind of taken a different turn this year as well. So anyway, it's interesting. And they did say we should expect to see more big news before the conference. So we'll see what that is. Their definition of big news might not be our definition of big news. All right, anything else? Slings, arrows? Victor had to jump.
Yeah, I just got asked the weirdest question, which has no legal tech line at all, but fascinating one. Somebody I know who is not a lawyer just asked me over text, does the new vaccine mandate apply to NFL teams? And I was like, they would be over 100 employees, I assume. I guess it's vaccine or testing, and most of them have testing protocols, but
Yeah.
so they're probably in compliance. But just out there for anybody who might have Cole Beasley or something, you might want to bench him, I guess, is that your takeaway.
Didn't like an assistant coach or something already have to resign because he didn't want to comply with the mandate or something? I think, yeah, I mean, yeah, like I mean, I think the league is free to impose their own policies. I mean, I'm not an employment expert, lawyer or sports lawyer, but I assume they're allowed to impose their own policies, and players, coaches are free to follow them or sit out. So.
Yeah, I'm just saying, I think that the new mandate is now their floor, like anything they can do over that. Yeah, but I think that does apply to them. Be very interesting. What's going to happen to some of these players? Nothing tech related there, but I thought it was a fascinating legal question that I had not thought of at all until I saw it.
That'll be next year's debate question.
Yeah, I know, right?
Maybe. All right, well then, if that's it, Steve is back.
Just in time.
just in time. Last but not least, to say goodbye. Thanks to everybody for watching and listening, and we will be back next week and find out what happens and see you all then.
Bye, everybody.
Bye, everyone. Have a good weekend.